Good morning, Mr. McDonald-Reggers. Before you go any further, I'm not sure whether we're going to have a rolling live note. If we are, it would seem that we need to be signed in because mine just says password, sign in.
I can't help you on that, my lady.
So I wonder whether there is somebody who can help us. But nevertheless, I think we should.
I got an email.
Oh, I didn't get an email.
The hearing from Opus, but
I haven't had an Opus email. Anyway, perhaps somebody would be kind enough to see what they can do about that whilst we get started.
I have managed to sign in.
Oh, well done.
I've used Opus 2 before, and it's the same login as it was on the previous occasion, which luckily I've remembered.
Well, my lord has better memory than I do. I can't remember what my password might be.
My lady, that same trick works for me, but I'm afraid I haven't got a screen on this occasion. So.
But in any event, please, I'm sure someone will sort that out, please go ahead.
Well, my lady and my lords, I appear with Mr. Tim Jennings on behalf of GIC, who are the defendant stroke appellant, and my learned friends, Mr. Timothy Killen and Mr. James Partridge, appear on behalf of TICL, who are the claimant and also the respondent. And as my lady and my lords will know, this is an appeal from a decision of Mr. Nigel Cooper KC, sitting as the Deputy Judge of the High Court, in his decision refusing my client's application for a stay under the Arbitration Act of these proceedings, and also refusing my application to discharge an interim anti-suit injunction, and also allowing my learned friend's application for a permanent anti-suit injunction. Now, essentially, all these appeals really boil down to the question whether or not the proceedings, the dispute between the parties, is to be governed by New York arbitration or English jurisdiction. And essentially that means, what did the parties agree? There are essentially two grounds of appeal. One is the meaning and the effect of what we call the confusion clause. Hopefully that's as neutral term as it can be given to the provision. And secondly, whether or not the New York arbitration agreement and the English jurisdiction agreement can be reconciled. And I'll explain the background to each of those issues in more depth. Now, before I proceed, I understand that the court has a core bundle and a supplementary bundle and an authorities bundle. And my authorities bundle is split into two.
As well.
And I think it's 1 to 10 and 11 to 20. So
absolutely.
It's very, very symmetrical, which is always a good start. I also would mention, as my lady's already indicated, that these proceedings are being transcribed. I'm assuming we will not break for transcripts, but unless the court wishes to do so.
No, I think we shall not break.
Okay. And I just so you're aware, I have agreed with my learned friend a division of time which is essentially roughly equal, so that shouldn't be a surprise to anyone. Now, of course, as I say, there are two grounds of appeal. If my clients succeed on either ground, the appeal should be allowed. I'm going to structure my submissions in three parts. The first is a review of the contracts to the extent the court requires a review. I propose to go through the contracts so you can see what the provisions say. I will be referring to the contracts during my submissions anyway, but I think it is helpful just to have an understanding of all the provisions of the contract. Of course, I can dispense with that or shorten it or abbreviate it if the court thinks it advisable.
Well, I think you'll find that we've all read widely, but I'm sure an overview would be very helpful.
Very good. And then the second and third parts are really going to be concerned with the two grounds of appeal. The first is the confusion clause, and the second is the question of whether or not the two relevant provisions are reconcilable. Now, as far as the contracts are concerned, they are contained in the supplementary bundle. And these are contracts of reinsurance in relation to risks underwritten in the United States. Essentially, the structure is that Tyson is the original insured, the reinsured, who the defendants in these proceedings is a captive, Tyson, TICL, and my clients are one of the many reinsurers who have been engaged in what can be described as a very extensive reinsurance program. My clients subscribe to two different layers. It doesn't really matter how much they are, and they were for 10% each. Now, the contracts relating to each of the layers, I think, are materially the same. So we'll just be focusing on the contracts for one layer rather than both. Now, before I go through the contracts, it's probably worth considering the chronology, which one sees in the core bundle. It's very brief, at tab 6. Page 62, and I think we can, it's just a few entries, but we can pick it up at 12th of May 2021.
Yes.
And it says, the negotiations for the 2021-22 placement commenced on this particular day, and Lockton, who were the brokers, emailed my clients, the reinsurer, various documents and property values, and the email stated, the program will remain as reinsurance of the Tyson International Company Limited captive, and we will provide reinsurance certificates and the updated policy form in due course. And then on the 3rd of June, the broker, Lockton, also sent an email providing further documents and repeating the statement that reinsurance certificates and the updated policy form will be provided in due course. And then on the 30th of June, that's the next page, the broker sent what's been described as the MRC policy documents. This is going to be the first of the contracts which we are going to visit in a moment. Now, it says MRC. I'm just going to use the word slip because it's the easiest thing and one syllable. You can see that the MRCs, or the slip, were signed and stamped by GIC on the 30th of June.
I'm sorry to interrupt. Can I be clear who Lockton were acting for?
They were acting on behalf of TICL.
That's what I assumed.
Yeah.
Thank you.
And then I think we can skip the 1st of July. On the 5th of July, there was a general change endorsement, which is a document which my learned friend refers to and relies upon, and I'll let him explain his submissions in relation to that, but I just draw your attention to it. And then on the 6th of July, Lockton prepared and sent draft facultative certificates on the Mura form to GIC. So this is, again, they're called either Mura or certificates or facultative certificates. I'm just going to use the word certificate. So we've got the slip initially, followed by the certificate subsequently. And then on the 7th of July, Mr. Gupta, an underwriter at GIC, as directed by Mr. Haslam, who was the head of property at GIC, confirmed that he was happy to accept the reinsurance certificate, subject to the following amendments, which includes the confusion clause. And I'll come to the certificate momentarily. And the 8th of July, Lockton incorporated the amendments and recirculated the certificates for approval. And on the 9th of July, GIC confirmed its acceptance of the certificates as endorsements to the MRCs, the slip. So that's the chronology, and we can put the core bundle away. And we revert back to the supplementary bundle.
Is there any magic in the word endorsement?
No. It's a word just essentially which means it can be a deed of variation or amendment. It's just you have a policy form which is followed by an endorsement. Nothing more. But it is, all I would say, it's a word commonly used in the reinsurance and insurance market. So let's go to tab 1. Page 3. This is the slip. So this is the document signed on the 30th of June 2021 by my clients. And it refers to the nature of the insurance, which is all risks of physical loss or damage. You can see the reinsured is identified as Tyson International Company Limited, or TICL. The original insured is Tyson Foods, Inc. The period is 1st of July 2021 to 1st of July 2022. The interest is referred to, but sum insured refers to the layers. And the next page, page 4, you have the situation, which refers to essentially the risks which are based in the United States. There is also a reference to the extension of what's described as contingent time element on a global basis, which is essentially business interruption insurance. But it's a property insurance with a business interruption edition. Then you have the conditions. and it begins policy wording, excess physical damage form. Now we'll come to that in a moment. That's essentially a standard excess form which applies when you're underwriting an excess layer as opposed to the very bottom layer. And it says, following terms, clauses, and endorsements of the original policy wording. So the original policy wording is the wording issued by TICL as insurer to Tyson Foods as the original insured. So the word follows there means incorporates. And then on the next page, you'll see a number of provisions, which will, and we may come back to one or two, but the significant one, of course, for the purpose of today's appeal, is choice of law and jurisdiction on page 5, which provides this reinsurance shall be governed by and construed according to the laws of England and Wales. The courts of England and Wales shall have exclusive jurisdiction of the parties hereto on all matters relating to this insurance. And then there's reference to the premium of $1.8 million. And on the next page, page 6, there's reference to payment terms. This is payment premium of 90 days as attached, and we'll come to that wording in a moment. And it says any extensions to the premium payment condition to be agreed by the slip leader only. Then I think we can, I'll just take what I think is more relevant for our purposes. Page 13, we don't have to delay too long here. This is the standard excess physical damage form, which applies to an excess layer insurance. You can see clause 2, for example, that it incorporates the terms of the primary layer. Now, that's not referring to the original policy wording, which is issued to the insured, but it's the bottom layer issued by the relevant reinsurer. And then, I think we'll go to page 24, which you'll see reference to the premium payment date, which is 28th of September. And at page 25, there's a subscription agreement, which is the agreement essentially which applies to govern the relationship between the relevant reinsurers. Here there's only one, but it also identifies how contract changes can be made, basis of agreement to contract changes. And it begins all changes to be managed and agreed in accordance with the general underwriter agreement. Sometimes it's called GUA, G-U-A. And then finally, at page 36, you'll see the agreement itself, which is, this is the confirmation of the subscription by GIC for a 10% line of this particular layer, and it's signed on the 30th of June, 2021. So that's the slip. And of course, the key provision in this slip for today's purposes is the English jurisdiction agreement we've had a look at. Then at tab 3 at page 74 is it's been described as the original policy wording or the captive policy, but this is the policy issued by TICL as insurer to Tyson Foods as the original insured.
I'm sorry, go back to 36.
Yes, of course.
Forgive my ignorance. What is the difference between a written line and a signed line?
Well, it's a very good question. I'm not sure there's a... Unless,
I mean, they're the same amount in this one, but
I think what may happen is you do sometimes get an underwriter signing or writing a line of, say, 10%. And if the risk is oversubscribed, it can be reduced. And so when it's confirmed, it's a reduced sum.
Thank you very much.
So tab 3, page 74 is the original policy issued by TICL to Tyson Foods. I don't think we need to dawdle too long over this. It sets out all the relevant terms of the insurance, etc. I will come back and look at this once or twice. I just want to draw your attention to page 97. which has a choice of law clause, which is the law of Arkansas. Also on page 97, you'll have a cancellation provision, which I'll come back to later. And then at page 108, you have what's called a service suit clause, which allows or requires submission to the jurisdiction of a competent court within the United States. It's not terribly significant for our purposes today. So that's the original policy. At tab 4, we have the general change endorsement, which is the document I referred to, and I think my learned friend may be developing submissions in relation to that. But I may come back to it once during the course of my submissions. And then we come to tab 5, which is the certificate. It's headed Agreement of Facultative Reinsurance, the agreement. But you can see there is reference to the reinsurance certificate just under the name of the reinsurer. And these are the amendments which were referred to in the chronology. And so reinsurers have made the following amendments to this reinsurance certificate. And the first one is excluding ex gratia without prejudice payments and follow the fortune settlements, if applicable. The second one is reinsurance slip, so that's the slip, to take precedence over reinsurance certificate in case of confusion. That's the confusion clause. And the third is cancellation termination subject to no losses. And again, you'll see the extent of the coverage is the same as you would imagine, which is covering all risks of direct physical loss and damage, and the reinsurance period is the same. And then we go to page 122.
That's 1st of July, isn't it? The reinsurance period.
The period is 1st of July.
It's American notation.
American notation.
Yes. Thank you.
But this just this is signed on, I think from memory, the 9th of July. This certificate is signed on the 9th. And so page 122, you have terms and conditions. And it says, under the terms and conditions, required terms and conditions. And then it lists all the required terms and conditions, which is 1 to 26. And then it says additional terms and conditions, if applicable, and it's got items from 27 to 30. And for our purposes, there are a number of provisions here which are relevant, but of course the principal one is item 13, which is arbitration. But I'm going to come back to those in a moment. You'll see then reference to the premium and the premium payable due date, which again, using American notations, the 1st September 2021. And of course, the slip had a premium payment date of 28th September 2021. Then there's a service suit clause, which you can see, well, I say clause, service suit is identified. And then at page 123, you have the terms and conditions, which are identified as required terms and conditions on the previous page. And I'm going to take you to the more important ones. The clauses 2 and 3 essentially incorporate the terms of the relevant original.
The premium, there were 2 clauses about the premium in the slip, weren't there?
There were. But
there was one about, is it the same date,
28th of September.
It's 90 days, is it?
There's a 90-day cancellation. I'll come back to cancellation if I may, because it's a separate issue. But just to answer my Lord's question, if you look at page 24 of tab 1,
that's the cancellation.
Well, it says it shall terminate. So it looks like an automatic termination provision. So if this condition is not complied with, then this contract with reinsurance shall terminate on the above date, with the reinsured hereby agreeing to pay premium calculated at not less than pro rata temporis.
I thought I'd seen something, 90 days, is that right? On page 6.
That's right.
So what's 90 days after?
Well, let me give you
after the
So that's
7th
page
of July.
6. So it does say 90 days as attached. Then you'll see at page 5, so sorry, if you go page 4, you'll see the conditions of the slip. And at page 5, remember it says follow the original policy wording. So if you look at page 5, you can see there 90 days notice of cancellation as per cancellation clause in original policy wording.
Sorry, I don't see that.
I don't see that.
It's about halfway down page 5.
Ah, yes.
It begins with the number 90.
Yes.
Thank you.
And so when I have, I didn't read it out, but I drew your attention to the cancellation provision in the original policy wording, which is a 90-day provision. But I'm going to draw these submissions in relation to cancellation later when this issue arises. But I'm happy to address it now if you wish.
I'm just trying to work out what 90 days from the 7th of July is.
From the 28th.
From the 1st of July.
28th, 1st of October.
Is the 90th day from the 30th of June?
Yes.
Because there are 31 days in July, 31 days in August.
Correct.
And 28 in September.
So that's 90 days.
Right, so it all makes sense. But
it makes sense except when you get the certificate when it says 1st of September.
yeah. No, I understand that point. It's
yeah.
just I was trying to work out what it was under what 90 days was.
Yes. But you do have an endorsement in this slip which suggests automatic termination if not paid on the 28th of September. But you do also have an express incorporation of the 90-day notice of cancellation provision into the original policy.
We were on page 123.
123. Sorry. So these are the terms and conditions. So clause 1, 2, and 3 are basically incorporating the original policy. You'll see at page 125. Again, I'll come back to it later. Clauses 11 and 12 deal with cancellation and termination generally, but also in relation to non-payment of premium. And then clause 13 is the arbitration clause. And it begins as a condition precedent to any right of action hereunder, any dispute arising out of the interpretation, performance, or breach of the agreement, including the formation or validity thereof, shall be submitted for decision to a panel of 3 arbitrators. Notice requesting arbitration will be in writing, etc. And I think little f identifies the fact that it's a arbitration tribunal. So I'll read it out, it's probably easier. The panel shall be relieved of all judicial formality and shall not be bound by the strict rules of procedure and evidence. Unless the panel agrees otherwise, arbitration shall take place in New York, but the venue may be changed when deemed by the panel to be in the best interest of the arbitration proceeding. Insofar as the arbitration panel looks to substantive law, it shall follow the law of New York in accordance with the dictates of the governing law clause. And then it makes additional provisions in relation to the arbitration procedure. Now, the governing law clause is on the next page, page 126, which provides that insofar as the panel looks to the law of the jurisdiction as governing law, it will apply the substantive law of the state of New York without reference to that state's choice or conflict of law rules, provided, however, that the substantive law of the state of New York shall not be used to supplant, override, underlying court or other judicial body final decisions concerning the claims at issue. And then page 127, we have, again, a service dispute clause. And then at the bottom of page 127 is clause 26, the entire agreement clause. And it begins on the next page, this agreement, including any duly executed written amendments and endorsements thereto, and appendices, schedules, or other attachments made part thereof or expressly incorporated by reference, and the policy and any written endorsements, modifications, alterations, and cancellations thereto, and waivers and interpretations thereto, but only with respect to the claim in dispute, all as permitted under Reinsurance Agreement Clause 2 and Reinsurance Accepted Clause 3, shall constitute the entire agreement between the parties and shall supersede all contemporaneous or prior agreements and understandings, both written and oral, between the parties with respect to the subject matter hereof provided. However, this clause 26 shall not override or take precedence over clause 3. And clause 3 incorporates the terms of the underlying policy. And I think that's all we need to look at in terms of the terms of the the certificate, except for page 131, where you will see that it was the date's at the 8th of July, although it's agreed on the 9th of July, and it's referred to as reinsurance certificate, identifies the reinsured. You can see it says agreement practice GUA, which is the general underwriters agreement, which is something which was envisaged as an amendment under the slip, and then of course you have the relevant line. So that, my lady and my lords, are the relevant contracts. And so with that introduction, I hope it didn't take too long, we can then proceed with the appeal itself. Now, the judge held that the confusion clause, and I will come back to it, is a hierarchy clause giving precedence to the slip where the certificate was inconsistent with the terms of the slip. So essentially, the judge held that if there is an inconsistency between the two documents, the slip prevails. He also held that the jurisdiction agreement and the arbitration agreement in the slip and the certificate respectively cannot be reconciled, so they are inconsistent provisions. So as a result, the English jurisdiction agreement prevails. Now my client's case on appeal is that the judge misconstrued the confusion clause. It's not a hierarchy clause applicable in the case of inconsistency. Instead, it's a clause which applies and gives priority to the slip in a very defined, narrow circumstance, which is if the terms of the certificate are unclear, are uncertain, or indistinct. Now, I'm going to develop that submission in a moment. If, however, my clients are wrong on this first issue, and the judge was correct, that if there is an inconsistency between the slip on the one hand and the certificate on the other, then we say there is no inconsistency because traditionally arbitration agreements and jurisdiction agreements can be reconciled. So the second part of my submissions is going to deal with the first ground of appeal, the interpretation of the confusion clause. And I think I'm happy to say that there is no dispute as to the general principles of interpretation applicable to a contract of reinsurance, except one minor point, which I'll come back. This is the point which I'll come back to, which is whether or not it's permissible for me to say and for the court to consider how the clause might be better formulated if the intention were that it was to apply in case of inconsistency. My submission, just as a spoiler alert, I say you can consider it, and I'm allowed to say it. It's a question of how much weight you give to it, but it's still a consideration which the court can take into account. There is a further issue which I need to address before I can proceed with my submissions, and I think it's a point which is touched upon by my learned friend in a footnote of his skeleton, and it's probably worth having a look at. So just so I'm sure I'm doing justice in stating what the point is. And it's the core bundle, part 5, page 41. Paragraph 14 begins of this. Sorry, so paragraph 14 of the text says, whilst both grounds of appeal primarily concern questions of interpretation, and therefore admit only one correct answer, a degree of deference should still be shown to the decision of the first instance judge, as inter alia the duplication of the first instance judge's role on appeal is disproportionate use of the limited resources of the appellate court. And there's a reference to footnote 20 to the decision of the Court of Appeal in Trust Risk Group against AmTrust Europe. Now I'll go to that decision if it's necessary, either now or in reply. But all I will say is, of course, there always has to be respect paid to the decision of the judge below in any case. But there is nothing particular about issues of interpretation of a contract or a contractual provision. In particular, in this case, because issues of interpretation are traditionally dealt with as issues of law, and therefore this court is here to decide whether or not the judge was correct or not. Whether that is, that decision-making process is not borne by a question of deference to the judge's decision, having regard, for example, which might arise, for example, when dealing with issues of fact and evidence. This is not that case. And secondly, the authority my learned friend refers to is a decision which concerns jurisdiction challenges, which this is, but in the context where the judge below has to decide who has the better of the argument, applying the good arguable case test. But in this case, the judge below decided the matter on the balance of probabilities. There was a final decision rather than...
I don't think balance of probabilities is the right phrase. Balance of probabilities is where you adduce evidence and the judge concludes who has proved their case or not. What you mean is he decided it as a question of final conclusion as to the interpretation of the contract.
Yes, you're absolutely right, my lord. I may be doing Mr. Cooper KC a disservice, but I think he used the phrase on balance of probabilities.
But if he did, I think he's wrong, and I think
Yeah.
there's authority which says questions of construction are not a question of probabilities. Precisely because they're not questions of fact, but questions of law.
Precisely. But if the jurisdiction challenge had involved deciding who had the better of the argument, which is a different evaluative exercise, then I can understand my learned friend's submission, but this is not this case.
And the fact that he granted a permanent anti-suit injunction shows that you must come to a final conclusion.
Correct.
Rather than just a jurisdiction challenge.
Correct. So,
and there's no dispute that that's what we're dealing with. We're dealing with what is the right answer, not what looks as who might have the better case at this stage.
Exactly. And in order to decide what the right answer is, the deference to be paid to the judge is not a relevant consideration. I mean, of course, you can come look at the judge's reasoning, but just because it's the trial judge or the judge below who decided the matter, it's not like looking at a question of fact based on an assessment of evidence.
Well, there is a very interesting theoretical question, which is whether the ordinary meaning of an English word is a question of law or not. And there is some authority on that. But for practical purposes, we're going to be asked to decide what we think it means.
Correct.
And we will do that applying the usual principles of construction.
Excellent. And that's something...
Speaking for myself.
And that was something which I would submit all members of the court should do. So with that introduction, I will come to the question of the confusion clause. Now, again, I always say I'm about to do something, then I preface it with something else. But here, of course, there was an argument below which is not being rehearsed on appeal. And it was an argument raised by my learned friend, which is that given the nature of the certificate, it was an administrative document, had no contractual effect, and therefore did not had no contractual impact on the slip. Now, this was an issue which has been considered by the Court of Appeal in another decision on the same reinsurance program involving Partner Re, and the Court of Appeal on that occasion did rule that the certificate was a contractual document and did supersede the slip. Now, I'm going to take you to that because Lord Justice Mayles, who gave the leading judgment, did make a number of comments which are relevant to the inquiry which I would ask the court to make today. And that decision can be found at the Authorities Bundle, tab 13, so the second bundle. And so essentially the facts of this, the contractual arrangements of this case, and indeed let's say the reinsurance program, are more or less the same. I mean, there are obviously differences in relation to the relevant layers, etc. But the one noticeable difference between the two cases is that the relevant amendments, including the confusion clause, were not present in this case. As we'll see in a moment, and you can see it, actually you can see it at clause, paragraph 13 on page 267. In the previous year's reinsurance, there was a relevant provision, which, and you can see Lord Justice Mayles said, on the 30th of July 2020, Lockton emailed Partner Re attaching what was described as the facultative certificate, document which in appearance was a contract of reinsurance for the same risks on the Mura form. However, the email also attached an endorsement to the MRC form, which stated that, with effect from inception, the agreement of facultative reinsurance between Tyson, TICL, and Reinsurer Partners Re is agreed subject to the terms and conditions of essentially the slip. All other terms and conditions remain unchanged. And paragraph 14 says the covering email explained that the purpose of the endorsement is just to provide you protection that the fact cert is overall subject to the terms of the MRC. Now that was obviously a case where there is absolute clarity, I would say, that the MRC is intended to take priority over the certificate insofar as there's any inconsistency. And that's the way I think Lord Justice Mayles viewed it as well. But of course, that provision was not present in the 2021 reinsurance, which the Court of Appeal were considering on that occasion. So if we look at paragraph 37, page 269, Lord Justice Mayles referred to the decision of the judge below, Stephen Houseman KC, sitting as the deputy judge, where he says that the judge recognised that the MRC and the MURA, which is the slip and the certificate, cover precisely the same risk, period, and parties, and that each of them could or would be a self-standing and self-sufficient contract if viewed in isolation from the other. The question was whether the later contract varied or superseded the earlier contract. The judge held that it did, and he sets out the reasoning in paragraph 42. And you can see at paragraph 64 on page 273, Lord Justice Mayles essentially endorses the decision of the judge below. And in the process, Lord Justice Mayles made a number of comments which I would submit relevant to the task at hand. And in paragraph 42, under the heading Ground, this is page 270, under the heading Ground 1 Discussion, as already noted, there is no doubt the MRC, the slip, again, dated the 30th of June 2021, so it's the same date as the slip in this particular case, in the GIC case, was a valid and binding contract of reinsurance governed by English law and subject to the exclusive jurisdiction of the English court. The issue is whether the parties intended that contract to be superseded by the MURA, the certificate. And this requires an objective assessment of what the parties said and did. Their subjective intentions are irrelevant. And then in the process, you'll see a number of points are made by Lord Justice Mayles, and they're numbered points beginning at paragraph 45. Viewing the matter objectively, several points are clear. First, from the outset of their negotiations for the 2021 policy, the parties contemplated what were described as reinsurance certificates and the updated policy form which was provided by Rockton, acting as Tyson's brokers. This was a reference to MURA certificate. And of course, from the chronology, you will see the same intention was present in this case where the certificates would be issued. Paragraph 46, second, the parties were or must be taken to have been familiar with the nature and terms of the MURA, a widely used form of reinsurance contract in the US market, which on its face makes it abundantly clear what the term document is for. They would therefore have known that the MURA was an appropriate document to be used in order to record the terms of a contract governed by New York law and subject to New York arbitration. Conversely, they must have understood that it was an inappropriate, indeed misleading document to be used if the parties intended their relationship to be governed by the MRC, subject to English law and jurisdiction. Now, pausing here, so we would say the same understanding must have been present as regards my clients and, of course, TICL and their brokers. And so when we look at the certificate and we see required terms, and one of those listed terms is arbitration and governing law, it must have been understood by all concerned that that was New York law and arbitration. I think we can skip some of the points, like paragraph 47 and 48, but paragraph 49 is probably worth looking at. Fifthly, the entire agreement clause, this is clause 26 of the certificate, in the MURA, with which the parties must be taken to have been familiar, stated expressly that the MURA certificate shall supersede all contemporaneous or prior agreements and understandings, both written and oral, between the parties with respect to the subject matter hereof. Mr. Killen, my learned friend, submitted that this clause is irrelevant to the question whether the parties intended the Mura to have contractual status. If they did, the clause adds nothing, but if they did not, the entire agreement clause has no effect. However, I do not accept that argument. The issue is whether the parties intended the Mura to supersede the MRC. The fact that Tyson's broker sought and obtained Partners Re's agreement to a document containing a clause proclaiming that the document constituted the entire agreement between the parties and superseded all prior agreements between them is highly relevant. Indeed, it means that Mr. Killen's submission that there is nothing in the language of the Mura to show that it was intended to supersede the MRC is mistaken. Although the MRC is not specifically identified, the entire agreement clause states in terms that all prior agreements are superseded. That includes the MRC. And in paragraph 50, Lord Justice Mayles just makes the point that it's intended to have contractual effect. And he adds, I think on page 271, about 5 lines from the end, he says, another apparently deliberate change, clearly intended...
I'm sorry, where are you on page 271?
271, it's about 5 lines down from the top of the beginning of that page.
Okay, thank you, sorry.
Yes. Another apparently deliberate change, clearly intended to have contractual effect, was that whereas the MRC provided a premium was payable on or before 28 September, the Mura brought this date forward to 1st September. All this suggests that the 2021 Mura was intended to be the final contract of reinsurance for the 2021 policy year. Certainly it looks like a contract and contains everything needed to be a valid and binding contract of reinsurance. It resembles the proverbial duck. And then Lord Justice Mayles dealt with a number of arguments about business common sense. And at paragraph 54, he makes the point that if the Mura wasn't intended to have contractual effect, what's its purpose? And then there were other provisions, which we may come back to. So that's all I need to say about the decision of the Lord Justice Mayles for the time being. I would add, the judge decided this issue in my client's favour. So absent the confusion clause, the certificate did have contractual effect and did supersede the slip. And I think he went further and said he regarded himself as bound by the decision of Lord Justice Mayles and the rest of the Court of Appeal in the Partner Re case. So as I understand it, there's now common ground that absent the confusion clause, the certificate is of contractual effect and does supersede the slip. And we would say the same is true even if the certificate is treated as being amending the slip as opposed to superseding it. So the question arises, how does one look at and construe the confusion clause? And I'll ask you to look at it again. I know you're, I'm sure, well aware of it. It's a supplementary bundle. Tab 5, page 121. Very short provision. It's provision number 2, amendment number 2. Reinsurance slip to take precedence over reinsurance certificate in case of confusion. Now, I'm going to make a number of points. I think there's 7, but it might end up being 6 or 8. I'm not sure yet, but I think it's going to be 7, which essentially supports the notion that the confusion clause is not a provision which requires the slip to be given precedence if there's an inconsistency between the slip on the one hand and the certificate on the other. That's not its purpose. And I'm going to hopefully make good that submission by reference to a number of considerations. Before I do, it's just worth considering this, that the slip was agreed on the 30th of June 2021. It was always intended the certificate would be issued thereafter. The slip did have an English jurisdiction agreement, but 9 days later, the certificate was agreed with the amendment, the confusion clause, but also with required terms and conditions, which included, specifically identified a New York arbitration agreement and a New York choice of law clause. Now, if the intention of the parties had been, well, we want to abide by English jurisdiction agreement, the English jurisdiction agreement, it would be a very, very odd way of going about it by saying, well, we'll agree this certificate with the New York arbitration agreement, but because of the confusion clause, we will end up back with the English jurisdiction agreement. There would have been other ways to deal with it. one of the easiest ways to just say, well, there is no New York arbitration agreement. We won't require it as a required term. And I do recall, I mean, the other point I would make is, of course, this was signed as an amendment pursuant to the General Underwriters Agreement, the GUA. I mean, the effect is to supersede the original contract, but it's done through a mechanism allowing endorsements and amendments recognised at Lloyd's.
What do we get from that? Sorry, I haven't understood what the point is.
So the first point is it's an odd way to agree English jurisdiction by imposing it in the New York Arbitration Agreement and then relying upon a confusion clause to go back to the English.
I have that point, but then you made a point that it's done by way of amendment.
Yeah, it is. It's just that the parties always intended the certificate to be made, and the certificate was agreed. This is not a submission; it's just a background point. The certificate was agreed pursuant to a general underwriters agreement endorsement, and as actually was.
I'm not familiar with the GUA. Does it matter?
It doesn't. There's one point which I'll come back to in a moment, which Lord Justice Males makes, is when it comes to insurance and reinsurance contracts, what normally happens, or used to happen certainly, is you would have what's called a slip, and it's not intended to be this slip, and it would be followed by a policy. And in the
slip, as I understand it, was a very short scrap of paper, almost.
Well, I mean, it was short, but it was compendious because it had incorporated a number of different wordings. And what would happen is the policy would be issued with all the wordings included thereafter. So it was
binding, but always intended to be supplemented by a more fully fleshed out agreement.
Yes, although in the Marine Insurance Act, it's actually not binding. It's a policy which requires it to be binding. But that we don't need to worry ourselves because this is a non-marine insurance. But that procedure of having a slip followed by a policy indicates that the parties always intend that the policy issued later would normally supersede the earlier slip. Similarly, when you have a general underwriters agreement, the GUA amendment program, what you're intending is whatever is agreed pursuant to the amendment program, the GUA, would override what's ever in the earlier document. That's the understanding and the intention. And you'd have to have contractual. One of my submissions will be, if you're going to override, if you're going to change that perception, change that understanding, you need very clear words to do so. So I said I think there'll be 7 reasons. Let's hope there will be 7 in the end. But the first one is, it's a point I've already made. Why would an underwriter, it's a question of common sense, I say, why would an underwriter and a reinsurer agree to sign up to a wholly new provisions dealing with New York arbitration, which would have been known to the parties, as Lord Justice Males said, only to revert back to the jurisdiction agreement in the slip by means of the confusion clause. If the intention were to be bound by, the parties could be bound by English jurisdiction agreements and not to be bound by New York arbitration agreements, then the parties would not have agreed to the New York arbitration clause in the first place. TICL's construction, based on the confusion clause, therefore, is serpentine. So we say that this brings them into...
I'm not quite sure I understand what serpentine is.
Serpentine means that there's a direct way of doing things and a long-winded way of doing things, or a tortuous way of doing things.
Circuitous.
Circuitous.
Thank you.
Not direct.
I thought it meant snake-like, but...
Well, snakes coil and curve, and they're not... I mean, they can be very straight, but most of the time they're not. That's the idea.
I don't think we need to go into mythology as well.
No.
We have enough trouble.
So...
You're just saying, why double back on yourself?
Exactly. By a very, what I would regard as quite a clumsy mechanism. I just emphasize what my case is. The word confusion refers to where a term or provision of the certificate is unclear as to its meaning or its effect. And in those circumstances, if there's a lack of clarity, you are entitled to look at the slip. So let me give you an example. I mean, it's not a question of just mere difficulty of construction. It's if, for example, there's a notification provision which identifies in one part of the clause it says X should be notified, but in another part of the clause it said Y should be notified. There's no apparent reason for have different recipients of the notice. One could then look to the slip to answer the question. Or if, for example, there was some absurdity, if the limit was less than the deductible or the threshold, then you can look to the slip to answer the question. But what it's not intended to do, sorry,
these are technical terms which are all very familiar to everybody in court, but not to me.
oh, I'm sorry.
Limit, threshold, deductible.
Yeah, so
I think I understand what a deductible is. I don't understand what a limit or a threshold is.
Okay, a limit is, if I just a very simple example, and it's not intended to be simple because it just makes my explanation as clear as it can be. If you've got a limit of $1 million in a policy, that means, of course, the insurers don't have to pay more than $1 million. But often because with motor insurance, there's an excess of, say, £50 on a broken window. It's the same with most insurances. You'll have an excess, which is sometimes called a deductible or a retention, and that could be $50,000. So the $50,000 is something which has to be used up first before you go into the insurance cover, and then you've got a limit of $1 million on top of that. Now, it would be quite absurd if the limit was less than...
What's the threshold? That's when you...
The threshold is the retention or the excess. So once you get past the £50 or $50,000, you get into the insurance layer. That's all. And the absurdity is if the limit is less than the deductible. That's not something you would expect. The limit has to be more than the deductible.
And what you're saying is the confusion clause means that it's about confusion within the certificate, and the confusion within the certificate may be resolved by looking back at the slip, and so to assist you.
Correct.
Query how it assists you. But that means that precedence doesn't mean hierarchy at all, where the word precedence is used. It means the meaning of the confusing whatever it is within the certificate shall be resolved by looking at the meaning of that issue, as wide as that, within the slip, and that will be your answer. So precedence means find your answer.
Yes, although
I'm just trying to be terribly simple.
And also, may I say, very helpful, because
But that is what you're saying.
Yeah, I am, except with one qualification. I am saying the word precedence means precedence, because you do look, rather than to find the answer within the certificate, by some means of...
You find the answer within the slip.
In the slip. So that, to that extent, the slip becomes the dominant contractual document as opposed to the certificate. Whereas if you didn't have that provision, you might just be looking at the certificate, because the certificate supersedes the slip. So this is telling you,
This is telling you that where you've got something that you don't understand for one reason or another, there's confusion. I'm sure you'll make more submissions about that. Within one document, you look back at the other for the answer. That's all you say it means.
Correct. What I say it doesn't mean, which is my learned friend's case, which is if there's an inconsistency between the slip on the one hand, in terms of the provisions in the slip on the one hand, and the provisions of the certificate on the other. That's what I say it does not mean. And just because, I think the judge said, well, you can have, and I think my little friend submits, well, you can have a confusion between two documents, so that if you've got an inconsistency between the slip on the one hand and the certificate on the other, that is a confusion, it's a conflict. But I'd say that's not the case. The parties will understand, for example, the premium payment date. It was 28th of September in the slip, and the 1st of September in the certificate. Yes, they're at odds with each other, although I think my little friend may take issue with that. They're at odds with each other, I say, but there's no confusion. One knows what the certificate provides. It's not a question of confusion. There may be an inconsistency, but just because there's an inconsistency doesn't mean the result is one is confused.
What sort of confusion are you going to have, as an example, within the certificate that can be resolved by trumping it by a provision in the slip?
Well, you could have a provision which says two opposite things. One contractual clause in the certificate says two opposite things, and it's very hard to resolve. But all you need to do is look at the slip to see if a provision deals with the
About
same.
what, just help me with my imagination, about what kind of thing, Mr. MacDonald-Eggers, would you have the potential within the certificate to have opposing
Well, just imagine,
clauses?
we saw in the slip, for example, there was a number of references to the payment of premium and what the consequence of non-payment of premium is. And at one point, it seems to suggest there's a notice of cancellation option, which means that the insurer or reinsurer could issue a cancellation notice to bring a contract to an end. There's another provision which says, actually, it's an automatic termination.
Okay, so there you have a conflict within the certificate.
Within the same document, though.
Within the same document, and you say, you look back and see what the slip says about it.
Exactly. And that's exactly where the confusion clause will, because if I read that, just assume you have two clauses next to each other in the certificate. And just to make it very simple, just imagine it says, the first one says premium to be paid on the 1st of September. The second one says premium to be paid on the 28th of September. And they're at odds with each other. That would create, anyone reading that would be confused. What's the right answer? And all you need to do is go back to the slip and see what says, well, 28th September there, that's your answer. Whereas if it just says in the slip 28th September for payment of premium, and the certificate says 1st September, there's obviously an inconsistency between the two provisions. But of course, normally the certificate will supersede the slip. There's no confusion. Because
they're both clear.
They're both clear.
What would happen if the certificate had two confusing clauses, 1st September and 28th September? You went back to a slip and it said 15th of September.
Then you would have to look, I mean, on that example, I imagine if there was confusing clauses in the certificate, then you get your answer of 15th September from the slip, and that would be the answer to your question.
So if the certificate said in one place New York law and another place said Arkansas law, you'd go back to the slip which says English law.
Yeah, in that scenario. I mean, of course,
it's pretty unlikely, but you know,
you never know. And of course, there may be other answers. You may have two choices of law in the one contract. One applies to the arbitration agreement, one applies to the contract. But if it's in very simple terms, yes, you're right. So my second point is
nobody does suggest here that the incorporation of the original policy incorporates Arkansas.
No, it's not, because you've got an express choice of law clause in the reinsurance slip or the reinsurance certificate.
I'm already out of sync with your numbering because I've
only done 1 point.
Oh, I thought we'd done two, because the confusion point I think was separate from why would you sign up to one thing which says one and then the other.
That's my first point. I call my serpentine point.
Okay.
My second point is question of language. I mean, one has to assume that parties agreed confusion deliberately. As I say, confusion means where there's an uncertainty or obscurity in relevant provision. Just because there is an inconsistency with the earlier slip does not necessarily mean, or does not mean there's a confusion.
But you also said it didn't mean just a difficulty of construction.
No, I mean...
Because, quite often you read a clause in a contract and you think, I'm not sure what that means. But that's not what you're talking about.
No, I think it means something where the position's opaque, where it's completely obscure what the parties were intending. So, for example, just imagine you have...
This is quite a significant, or maybe quite a significant point. Many contracts contain clauses which, when you first read them, you think, I'm not quite sure what that means. And sometimes, once you've read the rest of the contract and understood the commercial consequences, you think, oh, well, it's obvious. It must mean A rather than B.
Correct.
Sometimes you do all that, and you think, I'm still not sure whether it means A or B. I'm going to have to go and ask a judge. And sometimes the judge says A, and the Court of Appeal says B, and the Supreme Court says A. Now, how do you distinguish between a case where it's initially, I'm going to avoid using the word confusing, it's initially unclear what the answer is, but if you're a sufficiently competent lawyer, you can feel pretty confident you know what the answer is. And a case where it's initially unclear what the answer is, and you may think you know what the answer is, but other people think differently.
Can I answer that by saying it's a question of degree? Because if you take my earlier example, if you like, a very clear case where you've got the certificate giving two different dates for the payment of premium. Unless there's something else in the contract or in the certificate which helps you resolve that conflict by construction, then you would look to the slip. You may have a scenario where superficially a term of the contract is unclear as to its meaning. But that can be resolved by a process of iterative construction. And you get, as you say, you get there at the end. You might have, and that I don't think comes from the confusion, because you go through the process of construction. In between, it becomes grayer, I accept, but you might have a scenario where you go through the process of construction, and you still end up with two competing meanings. Now, sometimes those meanings can be resolved by reference to rules of construction, such as contra proferentum, etc. But here, I would submit that you could look to the slip to answer your question.
Yes, no, I think I understand.
Yeah.
It's probably quite a improbable contingency for contracting parties to be entering a contract thinking that the contract might contain something as extreme as you're suggesting. I'm not saying it's impossible, but it's quite an improbable thing to happen. Most contracting parties think that their contracts make sense. And they've, on your argument, they've entered into this clause to cover this very, I would suggest, extreme and unlikely set of circumstances.
Well, that may be right, but it's equally improbable, my lord, that, and just going back to my first point, is why would parties identify as a required term a New York arbitration agreement, which Lord Justice Mail says they must have been aware of, only to revert back to the English jurisdiction agreement by virtue of the confusion clause? That seems to me even more improbable. So,
although he did say in the same paragraph, you could turn that on its head, I think, and said equally you can say it's very improbable to enter into a binding English jurisdiction clause and then 9 days later enter into an arbitration clause. And so he, as I read that passage you just took us to,
yes,
he seemed to be saying it's kind of half a dozen of one,
and that's why
six of the other on that, if you're trying to weigh the improbabilities. And then he ends up saying, I don't think I can make much of this point.
Well, I think that's why my submission to you is this is a question of you have to construe the words on the page against whatever factual context exists. But whatever the question of probability or unlikelihood is not really for this court to speculate about. The question is, what did the parties mean by the use of the word confusion? And my submission to you is the word confusion, bearing in mind that my first consideration is the serpentine point, but the word confusion is deliberately used. In other words, when you have a hierarchy clause, for example, you could have used the terminology used in the previous year in the partner re case, which is the certificate is subject to the terms of the slip in all cases. Or you could have another term which says, in the case of conflict between this contract and the slip, or in the case of inconsistency between this contract and the slip, you could refer to, the slip will predominate. But it doesn't say any of that. The words conflict, inconsistency, subject to are not used. The word chosen and agreed by both parties is confusion.
And in a nutshell, what does confusion mean?
Where you look at the term, let's just say there's one particular term of the certificate and its meaning is unclear. It's obscure or uncertain. It's not just a question of construction, as I hope I explained earlier. It's a question of genuine ambiguity or a conflict within the provision itself.
How far do you go though? Do you say, I thought from the examples you used that you were actually giving examples of completely irreconcilable.
Well, that's the clearest case.
Which is why I called it a very extreme case. So you've got the premium is 100, the premium is 200. There's no way of resolving that. That's different, I would suggest, from obscure or uncertain.
Well, I think the word obscure and uncertain still apply to that irreconcilable.
I'd call it irreconcilable.
Okay, then I'm
Is
happy.
it more than irreconcilable?
Well, I in answer to my Lord's question before about where on the spectrum does the word confusion apply? I said if it's just a simple question of construction, it doesn't. If it's an irreconcilable point, it does. There may be somewhere in between where it also applies. For example, if you've got a genuinely ambiguous clause.
So, in a case of an ordinary construction which you can resolve as described, but in a case of a difficult point of construction which there are genuinely two arguable positions, it does apply.
Yes.
That's very clear.
Now, I think the key point to take away is just because you have a conflict between the slip and the certificate does not mean there's a confusion. It's clear there's a conflict, but you're not confused about it. And therefore, confusion is an inapposite term for that purpose. So if this were a genuine conflict hierarchy provision, it should have been better expressed. Now, my learned friend says I'm not allowed to identify other ways of expressing it, but I think it's the only way to deal with the submission. My learned friend also refers to an extract from, I think, a decision, perhaps of my lady, in a case called the European Film, where I think there's a reference to Lewison. But if you look at this, the extract, I haven't got it before me, but if you look at the extract from Lewison, it's not as black and white. This is a guide to construction, nothing more. But what I do say is that TICL is wrong when it submits in its skeleton that confusion means confusion between the slip and the certificate. That's not what this. That's not a natural or ordinary use of language. And I would go further. My submission is my construction is it doesn't require a rewriting of the clause. Just identifying what confusion means. That's what both parties are really concerned with. What does confusion mean in the circumstances of this particular contract? The third point I want to make is the use of words takes precedent doesn't really inform you about anything. I mean, I think my lady put it, if there is a genuine confusion, you look to the slip for your answer. I would say that conforms with the notion of taking precedence. But what is important in this context, and I think the judge below basically said, well, that tells you that you're looking for a conflict between the two documents. I disagree. What I would submit to the court, my lady and my lords, is that the word confusion is the trigger. It identifies the problem. The taking precedence provision is the solution. It's the contractual result of there being confusion, nothing more. And
can I just put this to you?
Yes.
This is the question of whether they could have, if that's what they meant, they could have said it much more clearly.
Yes.
Isn't that something that could be levelled at your construction as well? Because it would be much clearer in your construction to say, if any term of the certificate is unclear or ambiguous, then one could look to the slip to help inform the construction, and if necessary, prevail over what's in the certificate. I mean, is that not a perfectly valid riposte to your suggestion? You can always draft a clause which comes before the court for construction more clearly, and that's what all the citations seem to say. So
that's true.
So is it not, whichever side deploys this point, the other side has an equally valid and opposite point?
Yes, except for this. My submission is the word confusion conforms nicely, neatly, with the construction I put forward.
Yeah.
Just because, but the word confusion in my learned friend's case does not, because because you have a conflict between the two provisions, the two documents, is not a confusion.
Are we going to get into at some stage a dictionary definition of confusion and what confusion means and all that?
Well,
are we just assumed to know what confusion
well, I mean, I can take you to the Oxford English Dictionary definition is in the bundle if you wish to look at it.
It's not for me to tell you what you how you do your argument your way.
Yes.
Not for me to tell you how to argue your case, but
no, of course not. I understand.
I think I would like to know whether you're going to ask us to just use our existing knowledge as to what the word confusion means, or whether you're going to tell us what the word confusion
Well,
means.
I will. Let me take you to the second authorities bundle, which is tab 19, page 436. I should take you. I'm sorry. 431 is the first page. And because this is the Oxford English Dictionary, not the shorter Oxford or the concise Oxford, the definition of confusion does go on for quite some time. But if you go to 436, which is, we say, the apposite definition, it's definition number 8. It says the quality of being confused, indistinct, or obscure, said of objects of sensuous or mental attention. And you can see in the first quote from Bishop Butler is confusion and perplexity in writing is indeed without excuse. Now, I quite accept that an inconsistency within the same provision may cause confusion, but I don't accept that inconsistency between the slip on the one hand and the certificate does cause confusion, because one is looking at the certificate as the superseding contract. Because this is the point Lord Justice Mayles makes. He says this is paragraph 53 of his judgment. He says the general position is that the later wording supersedes the earlier, although the later, and he recalls the position with policies superseding an earlier slip. That's paragraph 53 of his judgment.
I think you said that on your argument, if there is confusion, whatever that may mean, then you don't just go back to the slip to see what the certificate means. So you're not just informing yourself with some useful ammo for trying to resolve the dispute. It actually then has contractual effect.
Correct, to that extent.
Would that arguably be rather surprising thing for the parties to agree? Because if the problem is one of, say, obscurity or lack of clarity or whatever in the certificate, on your argument, that's still the real contract. That's the one that they've all agreed supersedes the slip. And you might see a world in which they might say, well, then you can go back and look at other stuff, which pre-contractual stuff effectively, and the best evidence of that might be the slip. But is it not odd to say then that the contractual terms of the slip prevail? Isn't that a rather peculiar agreement?
No, because it gives you an answer to a problem. If there's a genuine confusion within the certificate, rather than having to resort to difficult questions of construction or looking at factual background or whatever it might be, there's a ready mechanism available, which is to look to the slip for the answer. And you might have I think my lord gave an example before, you might have a scenario where just the premium payment date, you have the choice between 1st of September and 28th September, and they're both said in the certificate. And you look to the slip and it says 28th September. Or it might say 15th of September. But either way, you're getting an answer. What you're not allowing the slip to construe the certificate, in the sense of you take it into account as an additional tool to construe the certificate. You're looking for the answer. And that's why it's a relevant consideration.
So it's like saying, we've agreed that the second document shall supersede the first, saving to the extent that we have messed up in the second document, and then the first document will prevail to the extent that we've not made ourselves clear in the second.
Correct.
But that does produce, picking up my lord's point, quite a curious result and quite a curious intention to ascribe to the parties. Because take the 1st stroke 28th September stroke 15th September example. It depends. You have a contract which on your case is intended to supersede. It produces either 1st or 28th. Now whether either of those prevails or the 15th prevails does not depend on which contract comes first, which contract supersedes the other. It depends on how easy it is to resolve the conflict between 1 and 28 in the second contract. If it's easy to resolve, and you don't get to 15th, when it slips into being more difficult to resolve, or impossible to resolve, you don't get either, you get to 15th. So the debate then becomes, how confident are you when you look at the second contract that the parties meant the first prevail over the 28th? If you're confident, then it does. If you're not confident, you don't get either, you go to 15th. It does seem a slightly, I'm not going to say serpentine, but Byzantine intention to ascribe to the party.
I disagree respectfully, my lord. I don't think it is.
It's my use of the word Byzantine. I'm sorry. It's an unusual intention.
I think you'll find, my lord, a confusion clause by its very nature. The use of the word confusion in this context is unusual. Yes. I don't know of another case where the word confusion has been used in this context. At least none that's litigated before the courts or in arbitration. So we're beginning with a term which is unusual in itself. And so whatever thoughts one may have about whether or not the intentions of the parties, objective or otherwise, is unusual or not, doesn't really get you very far, because you have to ask yourself, what does this term mean, having regard to the terms of the contracts which we know exist. Okay. I would, before I leave this point, and I will get quicker as I'm going along, so please don't think I'm slowing down.
It's our fault for asking you questions.
No, and they're very, very good questions. I just want to make one point before I leave this point. Just asked to turn to the core bundle, tab 5, page 43. My learned friend makes a point. This is my learned friend Skeleton. He makes a point at paragraph 18, which is that it's unclear how GIC's construction could sensibly operate as alleged, given 1, importing or referring to terms from an English law governed contract into a contract governed by New York law will likely cause more confusion than it resolves. And 18.2, unclear how the parties determine whether the requisite lack of clarity or uncertainty within the certificate has arisen if they are to be read entirely independent of the MRCs. But my first submission is, well, those considerations apply equally if my learned friend's construction is correct. You've got the question of inconsistency still arises, and you still have issues of how English and New York law may interplay. But similarly, you've got to work out, is there an inconsistency or not? And that brings us on to the second ground of appeal. So I don't think that's really a telling point as far as anyone is concerned. But I will make this point, that as far as choice of law is concerned, my submission will be to you when I get to it, is that if I'm wrong on the first ground, and you go to the second ground, that English law applies to the extent of the jurisdiction agreement, and New York law applies to the extent of the arbitration agreement and the main terms of the contract. But ultimately, it's going to be an issue for the tribunal or the court dealing with the substantive issues. But we say that these considerations really don't add anything to either party's case in terms of construction on the first ground. But I just wanted to draw your attention to that.
Nobody suggested that New York law had any role to play in the question before us.
No, and in most cases, when you're talking about choice of law on questions of construction, all you're really interested in is what are the principles of interpretation under the New York law or English law, and you often find they're very, very similar.
Well, if no one has suggested to the contrary, then the English court will assume that the foreign law is the same,
Correct.
whether as a matter of fact it is the same or not.
Correct.
But just as a matter of theory, because it's interesting, is the confusion clause to be is the construction of the confusion clause technically a question of New York law or a question of English law?
I would say New York law, but that
is that only if you win?
I win, but it's also
if you win, it's New York law, but if you lose, it's English law, isn't it?
It may well be, but it's a matter of submission to the relevant tribunal or court who has to decide this issue, if it becomes relevant in their circumstances. Because there may be other provisions which are at odds with each other that we don't know about, and we have to consider how it works.
Thank you.
So, hopefully, this is my fourth point, and if we go back to the certificate, the supplementary article, which is tab 5, page 121. We have a page 122, as I've indicated when I went through this document before, terms and conditions, required terms and conditions, and then a number of provisions specified, which includes New York arbitration and the governing law clause. Now, I would say it would be wholly surprising if the parties went to took the care to identify specifically what the required terms are. This is not just a question of incorporating a standard form contract. It's actually identifying what terms are to be agreed to be incorporated into this contract and expressly including arbitration for the parties then to dispense with the arbitration agreement in those circumstances. This is not just a provision which says the terms of MIRA are hereby incorporated. It actually identifies one by one the relevant terms which are identified as required terms. And required terms must be given a meaning. Now, the next point concerns I think I should ask you to look at my learned friend's skeleton again, I'm afraid, in the core bundle, which is tab 5. And it's page 48. Paragraph 35, my learned friend addresses an argument which I addressed below and also we make here today, which is if the confusion clause were to be given a construction along the lines that the slip prevails if there's an inconsistency between the slip and the certificate, then how does that explain the payment of premium? Because you have a due date for the payment of premium in the slip, 28th September, and a due date for the payment of premium in the certificate of the 1st of September. So on that basis, if you're taking this point and running with it to its logical extreme, even though the parties have agreed, I mean, if you go back to the certificate, I'm sorry, I hope it's still out, you'll see it's the term which comes immediately after the required terms and conditions. It says reinsurer's gross written premium, and then it says premium payable due date 1st September 2021. Now, if that's the case, the parties have gone to the trouble of agreeing this new date. Why is that overridden as well? And my learned friend says, paragraph 35.1, is on page 49 of the skeleton. Well, I think he says, he'll correct me if I'm wrong, that essentially there is no inconsistency because it has, depending upon the consequences of non-payment, which is termination or automatic cancellation or whatever. But I say that's wrong because there's still an inconsistency as to what the due date is. It's either the 1st of September or the 28th of September. And the cancellation provisions are complicated, and I'll come back to it in a moment. But in paragraph 35.2 of the skeleton, my own friend then says, as the judge found, given both the premium payable date and the cancellation provision, and I'll come back to the cancellation provision, were specific subsequent amendments as opposed to terms included as part of a pre-printed standard form, as the arbitration agreement and governing law clauses, there would be no confusion as to whether the provisions of the MRC or the facultative certificates applied in any event. These provisions would not be overridden. Now, so I think my learned friend is basically making an allowance that the premium due date is amended by the certificate, even though it's at odds with the premium due date in the slip. Now, I'd say, well, if that's the case, why is, it's just assuming my friend's right, why are the required terms, which occurs immediately before the premium due date in the certificate, not also specific subsequent amendments? This is not, as I say, the mere incorporation of a standard form. It's an enumeration of each individual term which the parties identify as required terms. There's no sensible distinction between the arbitration agreement on the one hand and a premium due date provision on the other. Now, the word...
There is a principle that pre-printed clauses carry less weight than ad hoc, bespoke clauses.
As a guide to construction, I guess.
Yes.
I accept that.
So is the point that here's a whole list of standard terms and conditions which are either required or optional, and they're all reproduced, not individually negotiated. But the premium payment date is individually negotiated. Is there anything in that?
Well, in a general sense, and you do see this in insurance and reinsurance contracts a great deal, if I may say so, which is you'll see, and my lord referred to earlier, the fact that you used to get, a scrap of paper and you might have a few provisions in it. And one of those provisions would be incorporating a particular market wording. Now, that market wording can be quite a long document and may even include a jurisdiction or arbitration clause in many cases. And there's a question as to whether they're incorporated. And if that's all there was, then I would accept as a matter of normal construction that a specifically negotiated term would take precedence over the incorporated provisions. There are two differences here. The first difference is this is not just a case of incorporating a standard form because the parties have gone to the trouble of identifying what are the relevant provisions to be incorporated one by one, and they've described it as required terms and conditions. That's the language which the parties have used. These terms, including New York arbitration, are required. So in those circumstances, it really should have no different status to the premium due date, which is also a specifically negotiated term occurring immediately after the enumeration of the required terms and conditions. The second point I want to make, of course, is on its face, what my learned friend describes as a conflict hierarchy clause doesn't make any allowance for any differences, whether it's premium due date or something else. And therefore, if that construction is a relevant construction, it seems to me that taken to its extreme, it can't be right. But if my learned friend has a point about what he describes as specific subsequent amendments, then it equally applies to the arbitration agreement, because it's identified as a required term. I'm just conscious of time. There's also a similar debate about whether there's a cancellation provision or not. My learned friend says in paragraph 35, well, the cancellation clause in the slip was struck through, and it was. But there is I drew your attention to a provision which says incorporates the original policy wording, including the 90-day notice of cancellation clause, which is in the original policy, was amended later, but it's still there. So you do, on my submission, have a 90-day cancellation clause in the original policy. You also have cancellation provisions in clauses 11 and 12 of the certificate. Plus, you've got the amendment on page 121 of tab 5, which is number 3, cancellation termination subject to no losses. So the question then arises, how does cancellation stroke amendment subject to no losses apply, having regard to the terms of slip? Now, one answer might be, well, it's in a specific amendment, and therefore it does have a higher contractual status of some sort. But it does still, it's a problem which does not arise on my construction. So the next point I wanted to make is, of course, not only have the parties identified New York arbitration as a required term, they've also identified the entire agreement clause as a required term. And this is a provision which Lord Justice Mayles referred to in his judgment in Partner Re. And therefore, if you take into account the confusion clause, the required terms and conditions which are enumerated, including the arbitration agreement, including the entire agreement clause, and the entire agreement clause itself, put all that together, you come away with the notion it's the certificate which is the predominant document, unless there's something within the four corners of the certificate which creates a confusion. however so created. And then you can look to the slip. But otherwise, it's the certificate which is the relevant contract, which would include the New York arbitration agreement. And then my final point on construction is that given the normal position, this is paragraph 53 of Lord Justice Mail's judgment, where the later document, later contract, supersedes the earlier contractual document. So here the certificate superseding the slip. If you're going to change that in any way, you would need to have expressly clear, in my submission, clear language. Whether you want to refer to this as the Mer shipping test or the Gilbert-Ash test or however you wish, but the normal position is that the certificate, the later contract, will override the earlier one. And if that's going to change, you need to have an express provision to that effect. And it has to be clearly expressed. And we say, in this case, it is not. And for those reasons, I would submit that the confusion clause should be construed as my clients submit, and the learned judge below got the construction wrong. So that brings me to the second ground.
Can I just check when you're expecting to finish?
That's 22. I'm hoping 20 to 1.
Go half an hour.
Half an hour.
Yes. It affects how many questions I ask you.
Oh, you can, I mean, feel free. I do much prefer it if questions are asked. Then I can tailor my submissions accordingly.
Yes, but it's important that you say what you want to say.
That's very kind of you. So the second, my lord, are there any further questions you have about my first round? Well, shall you leave it? You might leave it to the end, perhaps.
Let's leave anything to the end.
Okay, fine.
I mean, everything you say raises very interesting questions. But,
well, that's my aim, my lord. My aim is also to press upon the court that I'm right. But if I can entertain and instruct and make it interesting, then I'm also happy about
Entertainment
that.
along the way. Round two.
Round two. So if TICL, my learned friend, is correct on the first round, which is the confusion clause must be construed as applying the slip to take precedence in the case of any inconsistency between the slip on the one hand and the certificate on the other. Then we say that really only applies if the inconsistency is irreconcilable. And in this case, it is not. There is the English jurisdiction agreement and the New York arbitration agreement are not irreconcilable. And the judge was wrong so to hold. And what I propose to do is firstly just make good the point. My lady and my lords, there's three decisions I was just going to take you to very briefly. They all say the same thing, which is basically where there's an apparent inconsistency in the contractual language, one should strive to reconcile them if you can. If they can't be reconciled, then you can't. Maybe I'll just take you to the first one, and we'll see the other ones later. The first one is Authorities Bundle, tab 3, so it's the first bundle. And it's a decision of Mr. Justice Christopher Clark, as he then was, in Ace Capital against CMS. And the tab 3, and it's page 98 of the bundle, not the report. And in paragraph 68, Mr. Justice Christopher Clark says, in Paul Smith against H&S, a license agreement contained in clause 13 a mandatory ICC arbitration clause in respect of any dispute or difference concerning the construction of this agreement or the rights and liabilities of either party. It also provided in clause 14 that the agreement should be interpreted according to English law and the English courts should have exclusive jurisdiction over it. Steyn J, as he then was, rejected an interpretation that would have confined clause 14 to cases falling outside the scope of clause 13 on the basis that would mean reading the relevant sentence of clause 14 as providing subject to clause 13, and that the linguistic manipulation required in the business-like spectre of some disputes going to court and some to arbitration militates strongly against this interpretation. He resolved the problem by interpreting Clause 13 as a self-contained agreement providing for the resolution of disputes by arbitration, and Clause 14 is specifying the lex arbitrii, or curial law, governing the arbitration and determining inter alia the extent of the court's supervisory jurisdiction. He did so even though the language of Clause 14 was infelicitous over it. And then if we go to paragraph 70, these cases, is also referring to another, sorry, the judge is also referring to Shell against Coral Oil. These cases all illustrate the principle that the contract must be read as a whole, and every effort should be made to give effect to all of its clauses. The meaning of one clause may be affected by the content of other clauses in the agreement. A clause should not be rejected unless manifestly inconsistent with or repugnant to the rest of the agreement. It is only if this cannot successfully be done that the court will treat a clause that has been specifically agreed as prevailing over an incorporated standard term. And this notion of the court striving to give effect to all clauses, even if superficially inconsistent, is a theme which is identified by the Court of Appeal and the High Court in other cases. And I'll come back to one of those later. Now, we say in this particular case, there is no irreconcilable inconsistency, which engages the confusion clause. And the forum provisions in both the slip and the certificate can be reconciled by giving effect to the New York Arbitration Agreement to deal with a substantive dispute and giving supervisory or auxiliary jurisdiction to the English court. Now, that supervisory jurisdiction is identified, for example, in Section 2 of the Arbitration Act, 1996, which identifies what powers exist as far as supervisory jurisdiction is concerned to arbitrations where the seat is outside England and Wales. You'll also see, and I think I'm going to take you to this now, in a decision of Mr. Justice Cook in Sul America against Inessa, which is tab 4 of this bundle, same authority bundle. Page 113. Before I go there, I should just show you page 103. You'll see, this is the head note. You'll see in this case there was an insurance policy which was expressed to be governed by the laws of Brazil. And then there was you can see this in the quote on page 103, any disputes arising under, out of, or in connection with this policy shall be subject to the exclusive jurisdiction of the courts of Brazil. And then there is, in the second half of the quotation, you'll see there is an arbitration agreement. So disputes have to be referred to arbitration. And at the very last quote is, the seat of the arbitration shall be London, England. So the question arose, how do you reconcile a Brazilian jurisdiction agreement with an English arbitration agreement? And if you go to paragraph 47, page 113, I won't read it out, but Mr. Justice Cook was making the point which Mr. Justice Christopher Clark just made about having to strive to reconcile apparently inconsistent provisions, particularly in the second half of that paragraph. You can see reference to Paul Smith. And indeed, you can see reference to, at the beginning of the paragraph, to AC and CMS, Mr. Justice Christopher Clark's decision. And in paragraph 48, Mr. Justice Cook says, the English courts, when faced with an exclusive jurisdiction clause and an arbitration agreement, looked at a strong legal policy in favour of arbitration and the assumption that the parties, as rational businessmen, are likely to have intended any disputes arising out of the relationship into which they have entered to be decided by the same tribunal. Unless expressly provided otherwise, the parties must be taken to have agreed on a single tribunal for the resolution of all disputes. A liberal approach to the words chosen by the parties in their arbitration clause must now be accepted as part of our law. I follow in this regard the comments of Mr. Justice Clark. Then paragraph 49 on the next page is, in the present case, on the construction that I have held, all disputes or differences can be and must be referred to arbitration under the terms of Condition 12. If that is so, what is left of the exclusive jurisdiction of the courts of Brazil under Condition 7? The answer is very little in practice. much the same as found by Mr. Justice Christopher Clark in paragraph 82 of his decision in ACE, enables the parties to found jurisdiction in a court in Brazil to declare the arbitral nature of the dispute, to compel arbitration, to declare the validity of the award, to enforce the award, or to confirm the jurisdiction of the Brazilian courts on the merits in the event that the parties agree to dispense with arbitration. It specifically operates to prevent the parties proceeding in another court on the merits. Use of the Condition 7 rights for these purposes does not detract from the arbitration clause, but gives them meaning. Furthermore, enforcement in Brazil against Brazilian parties is self-evidently a realistic possibility. The effect is, of course, to give priority to the arbitration clause over the exclusive jurisdiction clause, but there is no other way of reconciling the two. Give full width to the exclusive jurisdiction clause would be to exclude the right to arbitrate altogether. The only other option would be to allow both the right to litigate in Brazil and the right to arbitrate to run in tandem, with the potential for a race to judgment between the two. That, the reasons given, is the most unlikely construction of Tyson's contention. Now, in the process of dealing with this dispute, Mr. Justice Cook dealt with another issue as to what the law applicable to the arbitration agreement was in circumstances where there was no express choice, and he basically said English law in those circumstances. And that issue went to the Court of Appeal. So the issue on the reconcilability of the two provisions itself wasn't addressed, although it was referred to. And I would ask you to consider Lord Neuberger's decision. I think it was Lord Neuberger. Sorry, I'm very bad at these things. Yes, Lord Neuberger, at paragraph 61 and 60 of the judgment, where he sort of endorses Mr. Justice Cook's approach. But I would add, even though Mr. Justice Cook said that there's precious little for the supervisory jurisdiction of the chosen court, he does identify certain issues which may arise, but also I would add to that the provisions of Section 2 of the Arbitration Act, which also identifies the supervisory jurisdiction of the English court in relation to foreign arbitrations. So that's the first decision. Now, the point I wanted to make about that authority, and I'm going to take you to one further authority in a moment, is this. My submission to you is that the authorities established 3 points.
I know I don't want to spend a lot of time on it, but that was ultimately an exercise of construction, wasn't it? It's
Yes.
not a rule of law.
No, of course.
And there was no hierarchy clause in that case. So he says in 50, there's no other way of reconciling the two. And then he goes on to say, because there's no mechanism for doing so, this is the best way of interpreting the party's intentions.
Well, there is a decision which I'm about to come to,
Okay.
where the relevant judge carried out what Clendenin described as an exhaustive review of the relevant authorities, and in a very illuminating way, I have to add. But one of the points that judge made, and echoing others, I think including Sir Thomas Bingham, is just because there's a hierarchy clause, one should not be predisposed to find that there is or is not an inconsistency. So the question still arises, on my submission, for the hierarchy clause, in this case, on the assumption my first ground is wrong, or in any case, that there has to be an irreconcilable conflict between the two provisions.
So you first try and reconcile the two provisions.
Yes.
And then if you can't do that, the hierarchy clause is a tiebreaker.
Correct. Now, I'm going to take you one more case, just given the time available, which is the decision I've just referred to, where the learned judge made an illuminating and comprehensive survey of the law. But there are 3 points I would ask the court to take away from these authorities. The first is that an arbitration agreement and an exclusive jurisdiction agreement in the same contract can be reconciled. 2, this is so even if they are located in different constituent documents. So if you get a slip and a later policy. Or it could be an original agreement and a variation. And third, this is so, this reconciliation can still take place even if the seat of the arbitration is in a jurisdiction different from the chosen jurisdiction. So as was clear in the Sul America case, Mr. Justice Cook's decision, that was a Brazilian jurisdiction clause and an English arbitration agreement. Of course, in this case, we've got an English jurisdiction clause and a New York arbitration agreement. So the final decision I wanted to take you to is this. It's the second authorities by tab 11. Called Surrey County Council against Sewers Recycling. The decision of Mr. Alexander Nissen, QC, sitting as a judge of the High Court. Tab 11?
Yes.
Yes. It's got a funny page. It's page 230. First page. And essentially, there's a waste disposal project agreement. You can see that referred to at the very beginning of the head note, WDPA, which I think was agreed in 1999. And then there were 3 subsequent deeds of variation. And I think the ones we are interested in were in 2010 or later, so 11 years later, the deeds of variation. Now, you'll see at paragraph so page 237 of the bundle, not the report, you'll see reference to paragraph 36. You'll see reference to the WDPA, and there's a dispute resolution clause, clause 51, which is an expert determination, and then clause 52, which is on the next page, paragraph 37, which provides for arbitration. LCIA arbitration, so London arbitration. You see that on the second column, paragraph clause 52.4. At page 239, you will see the deeds of variation, DOV 1 at paragraph 39 and DOV 2 at paragraph 41, which essentially have English jurisdiction agreements, no reference to arbitration. And a dispute arose, which I think fell within the subject matter of the variations, and the question arose whether it was arbitration or English jurisdiction. And the court had to ask itself whether or not the arbitration agreement in the original contract, made 10 years before, was operative, or was it overridden by the jurisdiction agreements and the deeds of variation, which were made obviously 10 years later. Now, the only other provision I would ask you to note is that page 236, paragraph 24, which clause 2.4 provides, in the event of inconsistency or conflict between the provisions of this deed, including its schedules, and those of the WDPA, including its schedules, ... the provisions of this deed shall prevail. So there you've got an express reference to inconsistency between the two documents.
Sorry, where's that?
At the bottom of paragraph 24, bottom of the first column,
Yes,
page 236.
sorry. Yep.
And there are, I won't read them out, but paragraphs 43 and 45, page 239 to 240, set out the parties' submissions. And you can imagine what the submissions are. One party says there's an operative arbitration agreement, the other party says, no, there's not. The judge, as I say, looked he reviewed 4 different strands of authorities dealing with different issues. And he concludes his review at paragraph 77, page 249. And he draws the following principles from that review. So from all these cases, I draw together the following principles so far as they are relevant to the present case. A, whilst the exercise is ultimately one of routine construction, where possible, the court should strive to give effect to an arbitration clause in the presence of a competing jurisdiction clause. It has latitude to do so where there is implicit drafting, but cannot do so where the clauses are in direct conflict with each other and wholly irreconcilable, and so that no sense whatever can be given to the attention of the parties. B, unless and expressly clearly say otherwise, there is a strong presumption that parties are assumed to have agreed on a single tribunal for the determination of all their disputes, at least when there is only one agreement between them. Dispute resolution clauses require certainty, so parties know where they should go where a dispute arises. C. Where there are two agreements, each containing different provisions for dispute resolution, the outcome may depend on the nature of the second agreement and its relationship to the first. A second agreement which varies the first one will probably be regarded differently from a second agreement which makes a clean break from the first one. The desire for one-stop shopping means that where possible, the clauses should be regarded as mutually exclusive in their scope of application rather than overlapping. However, some degree of fragmentation may be inherent in what has been agreed, in which case the centre of gravity of a given dispute will be relevant. And D, where a contract contains a hierarchy or conflicts clause, there should be no predisposition to find or not find a conflict between the two clauses. The ordinary rules of construction should first be deployed, and only if those result in a conclusion that the two provisions are irreconcilable is recourse to the conflicts clause required. I did not understand Mr. Constable QC to dispute this approach. And you can see in paragraph 79, the judge concludes that the parties in this case intended the dispute resolution provisions in the WDPA to remain applicable for their substantive disputes arising in respect of the construction of the echo part, which fell within the relevant variation. And so I think that's all I need to take you to, except for paragraph 88 on page 250. It follows that clause 52, which is the arbitration agreement, should be read as encompassing disputes arising out of or in connection with the agreement, as from time to time amended. And on the next page, 251, paragraph 91, the judge says, I recognise that stripped of the clauses falling within the scope of the variation, the remaining provisions and deeds are largely standard ones concerning, for example, counterpart service of notices and exclusion of third-party rights. It's therefore unsurprising that the parties should leave those largely procedural matters in the hands of the courts by virtue of clause 15. And if clause 15 were left with very little purpose in practice, that would not be a reason to reject the application of the arbitration clause. See the decision of Mr. Justice Cook in Sud America, paragraph 49. And then in paragraph 92, clause 52 should continue to be broadly construed in keeping with the approach promoted by Fiona Trust. Now, that decision supports the notion that the arbitration agreement and the English jurisdiction agreement, in this particular case, can be reconciled. And it's worth noting that even though there was a hierarchy clause in the deed of variation, which did not contain the arbitration agreement, that did not stand in the judge's way of trying to reconcile the two provisions by holding that the arbitration agreement still applies to the contract, even as amended by those variations. Now, so I think we can put that away. What I would say, finally, is ask you to go to the core bundle, back to my learned friend Skeleton, and this is at page 54, tab 5. Paragraph 45. Now, my learned friend gives 4 reasons why the New York arbitration agreement and the English jurisdiction agreement cannot be reconciled. The first is, paragraph 45.1, the confusion clause itself. But as I've submitted already, just because there's a hierarchy clause, and of course we're operating on the assumption in this context that I'm wrong about its construction, does not predispose the court to find that there is or is not a conflict between the two provisions. The second, paragraph 45.2, which is there is a differing choice of law provision in both contracts. Now, if one has to consider this at this juncture, of course we're concerned with 4 of not choice of law, but if one has to identify, for example, the role of the choice of law in relation to each, one would say that the English law applies to the extent the jurisdiction of English courts apply, and New York law applies to the extent that the New York arbitration agreement applies, but they're still reconcilable, both of them. The third is that there are 2 documents here rather than 1. Well, of course, in Surrey against Sewers, the case we've just looked at, you had an original agreement and you had 3 deeds of variation which followed, just because there's one document or 2, or you might be incorporating a standard set of terms. That doesn't change anything because you still have one contract of reinsurance in this particular case. And the final point I think my learned friend makes, if I've got it right, is, well, the language is quite prescriptive. It relates to all matters falling within the jurisdiction agreement. But that was the same wording which you see in the Sul America case. Mr. Justice Cook did not say that that stood in his way. He reconciled the provisions in any event. So we would say in those circumstances, none of the points raised by my learned friend, paragraph 45, are a bar to the reconciliation of these 2 provisions. And therefore, New York arbitration should be given effect by virtue of that process of construction. And you do end up in these circumstances with a single forum to deal with the substantive dispute. But if it's necessary, assuming I'm wrong about my first ground, then you have the court's supervisory jurisdiction in play to the extent it's required. And so, my lady and my lords, for those reasons, I would submit that the appeal should be allowed. And of course, I'm a bit ahead of schedule, so this is a very good time for questions, if there are any.
I think the answer is no, thank you.
Very disappointing.
Thank you very much. Mr. Gillen.
Thank you. My lady, my lords, I gratefully adopt Mr. MacDonald-Eggers's structure, and I will go along the same lines. I'll start very briefly, if I might, to just pick up a few points of background, a couple of corrections or clarifications on things that we say are potentially of some relevance. I'll then move to some general observations on the nature of this appeal. That will, I hope, be quite short, but just dealing with the points as to the nature of the question of interpretation, whether there is a question of fact involved, and also whether there ought to be any deference in this case to the first instance judges. And I'll then take each of the grounds in turn. On ground 1, I propose to start with the wording of the clause itself, and then move to what I understood my learned friend to be relying on as essentially the extraneous points of construction, so the background fact, the commerciality. But we say really this is a case where, although the interpretation is obviously a unitary exercise, this is a case where the words of the clause do provide an answer. And the question in essence is, do any of the background points override what we say are the clear meaning of the words? And I'll then turn on to ground 2, addressing very briefly the interrelationship between ground 1 and 2, although I understand from my learned friend's submissions just now that isn't really in dispute. In my learned friend's skeleton, there were some suggestions that one might bring back the meaning of the confusion clause as something to argue about in ground 2, but we accept that if we're in ground 2, it's because we've won on ground 1 already. In other words, we don't say that there is confusion in the way, and I'll get to whether that really is something that can be understood by, let alone the reasonable reader, but certainly by me. If there is confusion in the way that my learned friend says there is, on the face of the single agreement read on its own, we don't say that one nevertheless argues about ground 2. So we're only in ground 2 if we've already succeeded on ground 1. And I will then address my learned friend's points there as to the general assumptions that underpin the argument on ground 2, and then the specific case law that's referred to and why we say it's distinguishable. So starting then just very briefly with a few points of background fact. My learned friend referred to what was called below, and in the other hearings, as the MRC, the Master Reform Contract, as the slip. I have no objection to calling it a slip, but what I would like to say is that insofar as by referring to it as a slip, there is some suggestion, as Mr. MacDonald-Eggers alluded to at one point, that it is a slip of the old form, so the type of short form slip that was scratched that incorporated other terms by reference with a policy to follow. That is certainly not the case. The Master Reform Contract is...
I'm not saying that, so if it helps.
I'm very grateful for that clarification. The reference, if I can give it, is the Authorities Bundle, tab 13, page 265, paragraph 4. That's where Lord Justice Mayles sets out the nature of the Master Reform Contract And essentially the point is, at the point of it being agreed, it is a complete contract. So it's not a temporary placeholder. The second very brief point is my learned friend referred to the original policy as being the policy with Tyson Foods. In other words, the underlying insurance. We say that isn't correct. Our understanding of the original policy, and what we say the original policy is the Beazley policy, which is the primary layer of the reinsurance. We can see that if we look at the authorities bundle, tab 13, which is in volume 2, page 267.
I'm sorry, you're just going to have to repeat that for me because I was just writing something down. So,
Of course. I'm not
I'm
sure, my lady.
looking for-
It's volume 2 of the authorities bundle,
Thank you.
tab 13,
Thank you.
page 267.
Thank you.
This is the judgment of the Court of Appeal in Partner Re, in Lord Justice Males's judgment. And one can see there, the wording on the MRC was the same. Paragraph 20, in brackets, what is meant by the original policy wording is described. It says, was the wording of the primary layer of reinsurance referred to in argument as the Beazley policy, led by underwriters at Lloyd's? Here, we have precisely the same wording, and so if one takes the supplemental bundle in tab 1, page 4, this is the MRC, and where it says conditions, the policy wording is defined, and it's with reference to the excess physical damage form, following terms, clauses and endorsements of the original policy wording capitalised, and then it gives a policy number, PRPNA 2103094. And if one then looks at tab 4 of the same bundle, this is the general change endorsement, page 116. And one can see that policy number, the original policy wording, at the top of the page, attaching to and forming part of policy number, and then we've got the PRPNA 2103094 number. That is the Beazley policy, so the primary layer of the reinsurance. Now,
I must say, I'd understood that that's what we were told. I don't know if there's confusion about this, but I thought he said that the original policy was the primary layer of reinsurance.
I don't think he did, but if he did, then
sorry, I may
agree.
have. That's what I picked up, but maybe maybe it's worth clarifying.
In cases, if there's any confusion, it's my fault. My learned friend's absolutely right. So that when it refers to the original policy wording, it's referring to the primary layer of reinsurance, rather than the policy issued by TICL to Tyson Foods.
Yeah.
Grateful.
Yeah, I had written down the reverse of what you've just said, so I'm very grateful for that clarification.
Very grateful. And the significance of this we'll come on to, but in essence it is that this general change endorsement that we're looking at here changes some of the terms of the underlying policy, so the insurance, and includes some bespoke terms. So it includes a communicable disease exclusion clause and a property, cyber and data endorsement and a sanction limitation and exclusion clause. The point, and I don't happily in this case, I say, need to put too much weight onto it, but the point in essence is that if the facultative certificate stood on its own, it incorporates the insurance, but not the Beazley policy. And so one, in essence, jettisons these specific endorsements that are part of the MRC. Whereas, if one continues to give the MRC contractual effect, as we say one should, then those specifically agreed clauses survive.
Do they survive because of the confusion clause, or do they survive because the slip MRC is not altogether superseded?
We say the latter. It's because the MRC continues. So there is no, we say, conflict in that sense that the confusion clause would bite on. So there is no communicable disease endorsement in the original policy. There is no sanctions endorsement. So they are additional clauses. They don't conflict with clauses of the original policy. But there are two ways that we say the MRC clearly survives. One is the fact that it is endorsed by the facultative certificate. So it, we say, in that sense, is clearly intended to continue to have effect, but with the facultative certificate endorsed to it as part of it. And the second thing is that we say the confusion clause confirms this. And when I come on to analysing the words of the confusion clause, we say that inherent within the confusion clause is that the MRC continues to have contractual effect. So it's not because of the confusion clause, my lord, but we say that that rather makes the point clear.
I thought Mr. MacDonald-Eggers suggested to us that it was common ground that were it not for the confusion clause, the MRC would be totally superseded by. What are you calling it? Are you calling it the facultative certificate? Can you agree on nomination for what the later document is?
Of course, a certificate, facultative
Certificate.
Yes.
I thought he told us that it was common ground, following this court's decision in Partner Re, that were it not for the confusion clause, the certificate would totally supersede the slip, and it now seems as if that's not common ground.
It's not quite common ground. In Partner Re, the facultative certificate was not endorsed to the MRC. It was simply issued. In the prior year, it was endorsed to the MRC, and there was what we say is a hierarchy clause, and was found by Lord Justice Mills as being a hierarchy clause. We say that the hierarchy clause is, to some extent, the more important of the two factors, but we say the fact that it was endorsed in that prior year is relevant, and we say the fact that it is endorsed in this year is also relevant.
And that if that were not the case, you wouldn't get the benefit of the Beazley policy provisions.
Precisely.
Thank you.
So, my lady, my lords, that is the point on the original policy and the Beazley policy. I'll refer to it again in passing later, and thankfully I don't think we'll have to trace through the policy numbers again. The final very brief point of background that I wanted to make is just to make clear that in the prior policy year in GIC's programme, there was also the hierarchy clause in the same form that had appeared in the prior policy year in the Partner Re programme that my learned friend took the court to earlier, and that was the subject to wording, so made it clear that the facultative certificate was subject to the MRC. Now, we say that's relevant in two senses. First, because we say that in that prior year, where there was a hierarchy clause and it was endorsed, Lord Justice Mayles held that it was clear in those circumstances that there was an English court jurisdiction clause. That's the first point, and English governing law, Lord Justice Mayles went on to say. The second point is that that is a background fact that can be taken into account, the fact that in the prior year, the policy was, for its entire duration, governed by English law and English jurisdiction. It isn't, I say, a point that I need to put any great weight on, but it is something that we say we note in passing.
Well, it's quite apparent from Partner Re and from the evidence in this case that each year is a separate insurance and that the terms may vary from year to year.
Yes.
So how does it help us?
Well, it helps us, I suppose, that in Partner Re, where what we say is a very similar form to the form that was used both in GIC in the prior year and in the year that we are concerned with, in Partner Re, where that was held to be governed by English law and jurisdiction, if the parties do near as damn it the same thing the next year, then the effect ought to be the same. Their understanding is the same. I did in Partner Re, unsuccessfully, as with I think most of my arguments in Partner Re, run a renewal point to say that if it was simply renewed, then one ought to look to the terms of the prior year. I'm not running that point here, but I am saying, as part of the background factual matrix, these parties, in what was a very similar form to the form that they used in the relevant year, did agree English jurisdiction. We say that is something that the court can and should take into account.
Was there argument in that case about the reconciliation point, if I can call it that? In other words, the second ground of appeal?
There was, yes. At first instance...
So that the two things could go together?
Yes, there was. At first instance, Mr. Houseman dealt with that point, and I think described it as an extremely challenging argument, I think is the quotation. I will perhaps come to that later. Right. It was argued in the Court of Appeal. It wasn't necessary to be determined, so it wasn't addressed in the judgment. As I'm sure my lady will
because it's a
remember.
reverse of this case, in a sense, because it was decided that the certificate in that case was the only contract.
Yes.
There wasn't anything to reconcile it with once that point had been decided.
Precisely, and it wasn't decided at Court of Appeal level. So, turning then to the general observations on the appeal, the first point I make is that this is the fourth time that the courts have heard these very arguments. They were made first of all ex parte before Mr. Justice Foxton, as he then was, then on the return date, fully argued for a day before Mr. Hancock KC, and then at the Section 9 application that is currently being appealed before Mr. Cooper KC. That was set down for 2 days, but we were done in the day. Now, we say that each of these three experienced judges and commercial practitioners concluded that, as TICL says, is obvious, the parties in this case agreed that both documents were to be read together and that the MRC and its jurisdiction clause was to take precedence. Now, I don't want to put this point too high, but what we do say is that the fact that this has come before 3 judges and 2 inter-parties hearings already, that at least some consideration ought to be given to this. This appeal is in essence a triplication of the first instance judge's role, and that is precisely the sort of thing we say that this court has previously cautioned against, and that is the reference to trust risk group and the judgment of Lord Justice Beatson, referred to in my skeleton argument. Now, I accept fully that this was a final determination by the first instance judge, and it was, to some extent, which I will come on to, a question which admits of only one correct answer, but it is a question which is a matter of interpretation of contractual instrument, a commercial instrument. It is in part, as I will come on to, something that depends on the ordinary understanding of the words used, and so we do say that whilst, of course, this court can, and if this court thinks those 3 judges have gone wrong, should interfere, there ought to be at least a moment of hesitation before doing so. I put it no higher than that.
We're not going to be troubled with the question whether this is an issue of fact.
Well, my lord, given that indication, I might take it very briefly, and I put it, again, no higher than simply saying that it is, we say, relatively broadly accepted that the meaning of words is an issue of fact. Part of my learned friend's case depends on the meaning of confusion. I am not saying that this court can only interfere if one thinks that no reasonable judge could have held as the judges before held. But I do say that this perhaps somewhat buttresses or relates to my first point, which is that if 3 judges have considered the word confusion and have considered that its ordinary and natural meaning in this context can encompass conflict, then again, that is probably something we say that ought to give some pause for thought. My lady, my lords, the third general point is to address partner re, and we say that much weight is put on the decision in partner re. As my learned friend has already alluded to, however, there are differences, and as was addressed also in the exchange with my Lord Nugee just now, there are, we say, important differences between partner re and this case. We say that it is relevant that in partner re in the prior year, Lord Justice Males found that that was subject to English law and jurisdiction, and we say it is very similar to this year in GIC's case. We also say it's relevant that Mr. Hancock and Mr. Cooper both considered the decisions in partner re when reaching their conclusions. So it is not as though one can say that this is a new factor that changes the lie of the land. That was something that was before both Mr. Hancock and Mr. Cooper. And Mr. Cooper fully considered the implications of partner re at paragraph 78 to 87 of the judgment. So turning then to ground one, and what we say is the primary and really the central question to this appeal, and that is the meaning of the confusion clause. That clause is, I'm sure, seared onto my lady and my lordship's brains, certainly is onto mine. It's at page 121 of the supplemental bundle tab 5. And obviously provides that the RI slip, so the MRC, take precedence over reinsurance certificate in case of confusion. Now, as my learned friend says, there is not really much, if anything, between us on contractual interpretation. I'm certainly not going to take the court to the authorities, but we do say that what is important to bear in mind is that one must consider the language used and then ascertain what the reasonable person with all of the relevant background knowledge would have understood the language to mean. And if there are two possible constructions, the court is entitled to prefer that which is more consistent with business common sense. Now, we say that in terms of the approach that ought to be taken, one ought to start, in this case, with the language of the clause and see what it means, and then turn to the background fact and the commercial considerations and see if they, in essence, change what would otherwise be the meaning of those words. Now, as to the meaning of the words, we say that this is necessarily primarily a question of interpretation, what that clause would mean, and we say to the ordinary reader, and we say it's important that it's to the ordinary reader and not to the pedantic lawyer. Now, starting there, what we say is that
all lawyers pedantic?
I'm not entirely sure if that phrase is tautologous or not, but it is often used.
By nature, okay.
Indeed. Now, what we say is that the interpretation put forward by GIC is the paradigm reading of a pedantic or perhaps a very clever lawyer. Even more so, we say it is a reading that really could only reasonably be reached by a lawyer who has been given instructions as to the result to be reached, in this case, namely New York arbitration, and has then essentially worked backwards to find a meaning for the clause that then allows that to be achieved. Now, I say I do very much admire Mr. MacDonald-Egger's creativity and ingenuity in the interpretation he's proposed, but we do say that no reasonable reader looking at the clause in isolation would consider that it mandates doing, as has been suggested, the reading of the facultative certificate in isolation, with resort to the MRC, something that my Lord Justice Miles pointed out is slightly bizarrely a contractual document that on GIC's case has been superseded and is otherwise of no effect, in order to clarify points that are said to give rise to confusion. And I must say, I did struggle somewhat to identify quite what the confusion on the face of the certificate is. Now, we say that the approach proposed by GIC is convoluted, it is complex, it is, above all else, unlikely. It is not a reading that an ordinary contract party in the position of an insurer or reinsurer would reach.
Can I pick up something? You referred to no reasonable reader. We know where you got that phrase from, it's well established. There are cases which say you have to ask who a contract is addressed to, what sort of reader we have in mind. I'm thinking of FCA and Arch,
yes,
and various other cases which say that. I think there's a case about a bill of lading which is addressed to bankers and so on. Who is this contract addressed to in your submission?
So this
who is the reasonable reader?
The reasonable reader is the insurer and the reinsurer.
It's not their lawyers.
No, it's not their lawyers.
Even though in practice, if a dispute arises, we all know that parties like this go and ask their lawyers what their contract means.
Of course, but I think the question is, do they use their lawyers to negotiate the contract? In insurance and reinsurance, no. It is done by the brokers, it is done by the insurer and the reinsurer themselves. So this isn't perhaps like certain bond issues or the like, where one might expect lawyers to be negotiating the term sheets. But in any event, even in those circumstances, I don't think that it is normally said that it is the lawyers that it is addressed to. It is the parties that are themselves binding themselves to the agreement. It is their understanding of what they say they are doing. And in FCA and Arch, it was...
Well, it's not their understanding, it's the reasonable, objective reader in their position. But
yes.
The point is it's in their position, not their lawyer's position.
Yes, precisely. Precisely.
And it must be because it's their agreement.
Exactly. Yes, Molly. And what we say here is there is no suggestion that the words of this clause are in some way a private dictionary between the parties. This isn't that type of case where this is a form of art. This is a term that is used in a particular industry. These are just the ordinary meaning of the words used as they would be understood by an insurer and a reinsurer.
I think there's some query of the private dictionary line of authority anyway, but it's not this case.
It's not one I rely on, my lord. I think that brings us to...
Mr. Killen, I mean, it's very difficult to break off this particular argument, but I think that perhaps is a convenient moment.
Certainly.
I'm very grateful to everybody for this morning. We'll resume at 2 o'clock. I'd be also very grateful if somebody could sort out a username and password both for me and for my Lord Justice Miles. Thank you very much.